Hello, good afternoon, or good morning, depending on where you are. I'm Constitutional Attorney Katherine Henry, and welcome to Restore Freedom Weekly, where I take your calls live so that you can get your legal and constitutional questions answered to try to point you in the right direction. Now, I am licensed in 5 different jurisdictions, including the United States Supreme Court, but I am not licensed in every jurisdiction. So keep that in mind. I can't necessarily give you a very specific set of advice, but more general guidance to point you in the right direction. So perhaps you know what kinds of questions to ask your attorney, or you know what kind of attorney you're looking for, or I'm just steering you in the right direction and representing yourself. That is my goal. Also, if you are a government official, maybe you're running for public office or you already currently serve in public office, I would love for you to call in and ask any questions that you might have. So I want to make sure that I'm empowering the people to hold their government officials accountable, but I also want to make sure I'm empowering the government officials willing to do the right thing, to have that knowledge and develop their skill set to do things in a constitutional fashion. So here's the phone number. Call in 616-303-0093. And hello? There you are.
Hi, Catherine, can you hear me?
I can hear you now, yes. Who am I speaking with?
Okay. This is Matthew Reardon with We the People News.
Okay, awesome. And where are you calling from?
I am actually, I'm in transit to Florida right now. I travel around the country and stress test the First Amendment.
Okay.
And I was actually invited on the show by Blue Line Transparency, so I want to say thank you for bringing me on here, Blue Line.
Yeah, so what state do you call home? I know you're on the way to Florida, but what state do you call home?
Well, most of my life I've lived in the corrupt state of Mississippi.
Oh.
And then my most recent issue involves the state of Louisiana. I didn't catch where you were out of, where you're licensed at.
Well, I'm actually physically in Florida, but I'm not licensed here yet. I am licensed in the state of Michigan, 2 federal district courts, a tribal court, and the United States Supreme Court.
Okay. Awesome. Well, good deal. Yeah, I got some very interesting questions for you. I'd like to get your feedback on.
Yeah.
So, I recently found out that U.S. Marshals had circulated bolos on me. For me being a journalist, conducting constitutionally protected, or me engaged in constitutionally protected activity. When I found that out through FOIA request, I did a protest outside of the federal courthouse where the U.S. Marshals were at. I held National Fuck the U.S. Marshals Day. Just had it, on signs, and I was baited up to the front door. The U.S. Marshals waved me up there, and long story short, my gear was broken over me during a violent arrest. What I call it, kidnapping. I was that led to additional torture, both at the courthouse and then where they had transferred me off to a sheriff's deputy to take me about 45 minutes away. So the first question that I have before I get into the really, rule stuff was, what constitutional protections apply when federal officers target and retaliate against a journalist like this?
I'm not sure exactly what you're getting at, because it seems like what you're saying is just what part of the Constitution, which would be the First Amendment, which you've already covered. That's the activity that you're going with. I would love to hear more about why they put a bolo out for you. What kind of specific activity there was. Was it obviously tied to a specific investigation, a specific case?
So Yeah, it all stemmed just from me going into the unsecured lobby of the federal courthouse. You know, there's you have the U.S. Marshals and the security service that has the security gate and the scanner and all that. But before getting to that, the unsecured area of the courthouse, I was in there just filming, and that all basically. I mean, that's exactly what led to them doing that. They actually, guys, it was 14 pages of heavily redacted material that I ended up getting from the Department of Justice General Counsel in Washington. Something just felt out of line, and I did a FOIA request to get it, anything involving my name, and lo and behold, they had put a bulletin out and picked three pictures that made me look like a dangerous criminal for holding a camera. But are you aware, like most courthouses, in fact, everyone, to my knowledge, has that part whenever you first walk in the doors, before you actually go through the scanner and all that. What is your take on before you get to the actual scanner inside of the entrance of the federal courthouse? Is that...
You can hear me? Hold on.
Is
okay.
that...
You cut out completely for a second.
Protected under the First Amendment.
Okay, so you cut out for a second there. Can you hear me?
Journalistic activity.
I don't think you can hear me. Can you hear me now?
I can hear you.
Okay, you weren't hearing me for a second. You cut out and then you weren't hearing me. So I don't know what my technology is doing, but it keeps switching back on its own to a different source of microphone and speaker. So anyway, so you were asking though, about when you first walk into a federal courthouse, and we'll just say federal courthouse because state courthouses are run differently. But federal courthouse, that before you go through security, so once you go through security, it's a different ballgame. But you're saying before you go through security, are there protections to utilize recording equipment? Is that your specific question?
That's correct. Especially when asserting that right, that I'm, that I am a journalist, that I was just filming the unsecured public area.
So, yeah. So, first of all, the reason why I make the distinction between federal and state, in case some are not aware, is, and I lost my live chat. I was going to bring that back up. Okay. So, the reason why I bring that up, that distinction, is because as of, I don't know how many years ago, I'm going to go out on a limb and say 10 years ago, maybe less than that. When I was practicing as a public defender in Ionia County, Michigan, doing misdemeanors and things of that nature, that's based in Michigan. That misdemeanors are done through the district court. There's three different trial courts in Michigan: probate court, district court, and circuit court. But that's done through the district court. And in Ionia County, Michigan, the probate court and the circuit court were in the main courthouse building, but the district court at the time was across the street, kind of kitty corner, and in a totally different building. And it was, I'm trying to remember, I'm pretty sure it was entirely unsecured. We did not have, you didn't go through security. There was no, attorney entrance and court employee entrance kind of thing. You know what I mean? Like in the basement there was for probation, because that's where they were, but that's a different story. But just to get into the courthouse, you didn't have to go through security. Now they had sheriff's deputies, on site for security purposes and being bailiffs and things like that. But you didn't have to go through security. There were no metal detectors or anything at the time. And so, that only changed when they, they added an addition to the courthouse so that the district court was brought over to the main courthouse building. And then, and they, changed the whole, security area. So now you go through the security to get to any of the 3 trial courts in Ionia County. But, and I want to, this long time ago, but based on what I remember being in, St. Paul courts, Ramsey County, Minnesota, and, in the courts in, at least in, Worthington, Minnesota, where I was also a public defender, many years ago. I'm pretty sure we never went through security. I don't remember having any kind of security or metal detectors or anything at the time. And, that was a small town in the middle of nowhere. And, it was many, many years ago. So that could all be changed now. But back at the time when we were doing all that, federal courts still were controlled by a different set of policies and, requirements. So, they
got the federal rules and regulations governing conduct on federal property, which is posted outside of every, federal building. And I guess, one of the things this comes down to is they claim that there's a local court rules or there's a local court rule signed by a judge, but I hadn't seen anything that had a judge's signature on it. But, can a local rule trump the actual federal rules and governing conduct on federal property that actually distinctly says that for news gathering purposes? I can't remember the exact word.
So I know exactly what you're talking about because I'm assuming that you might be aware of This Is a Public Service. Are you aware of him at all?
I haven't seen that channel, no.
Okay. Well, he's a good friend of mine. And I was actually his standby counsel when he was charged with various offenses relating to violating that portion of the GSA, the CFR on being his was a Social Security Administration building. But that particular court or that particular rule that he was charged with, and I don't have it all in front of me anymore. And I used to have all the numbers memorized, but it's just been so long now that, his appeal is actually still pending, but, the trial we had was a year ago. We were last in court, at least, after I was diagnosed with cancer, which was a year ago. So anyway, it was long ago enough that I don't, I just don't have it all memorized anymore. But my point being, the wording of that particular CFR, Code of Federal Regulations, that deals with going into, buildings for news purposes, there's like A, B, and C. So it's broken up into, if you're trying to get into, basically A talks about needing, verbal permission from the building tenant. B talks about needing written permission. And then C talks about, well, if you're just in the foyers, corridors, lobbies, auditoriums, basically where anybody can just be, it's not behind, closed doors, so to speak, right? That falls in section C if it's for news purposes. And just like you, that's what he does. He's a First Amendment auditor, so it was for news purposes. Although we actually they did argue that. Anyway, they tried to say his YouTube earnings made it not for news. And I'm like, how stupid. The New York Times gets paid. What do you think they do it for free? But anyway, so the point is, if you look at that specific CFR, it does. And they issued guidance that we also talked about and introduced as evidence in his trial as well. They issued guidance, the GSA issued guidance talking about, that yes, you have a First Amendment right to be able to record in public spaces, et cetera, et cetera. But with this particular thing, what they're saying, that the way the rule is worded is that you have a right in federal buildings to record, in those particular spaces, unless, unless there is, a specific, and I don't remember what all the words are, but unless there is a specific regulation or court order or something that excludes that or prohibits you from doing that. And so there is a provision in that court rule. What I'm getting at is there is a specific provision in that court rule that says if there is a court order that prohibits you from recording in that space, then you cannot record in that space. So there are standing administrative court orders that have been issued for all these courthouses that you can't record in those, in those spaces. Generally speaking, they're worded to be once you make it through security is essentially how it's worded, but not always. And quite frankly, I agree with you that you should be able, well, let me put it this way. Anywhere a person can go, if you have a lawful right to be there, like let's say you walk into a federal or state courthouse and you want to record you transacting normal business, right? So let's say it's my case that I'm working on a case right now to file with the United States Supreme Court. In my view, if I wanted to wear a GoPro, attach a GoPro to my chest and walk in and file the paperwork and transact all my business, get copies, my receipts, whatever, certified copies, whatever I'm going to do. And then I wanted to go and walk to, some other part in the courthouse or maybe an attorney general's offices or something of that nature. And I wanted to serve them with a copy. In my view, anywhere that I'm physically allowed to be, I should be able to record. Now, practically speaking, the courts will say no anytime, any day of the week. I don't think, but my legal view of this is the Constitution does not allow them to make rules or court orders that stop someone from recording when it is a place that they are generally allowed to be. Now, that doesn't mean that you could go have a camera and then zoom in on stuff that's, behind the desk. You know what I mean? So that you essentially would be viewing things that you did not have the physical right to walk over there and see. Because there's times where there's confidential court documents and things of that nature that, the public doesn't necessarily have the right to see, or maybe not in that moment. Maybe there's a protective order for some reason, or there's intellectual property concerns or something of that nature. Do you see what I'm saying?
Okay.
But
yeah.
my view is that if you're not doing it for those purposes and you're not doing that, you're just literally walking in and recording with a normal lens, anything that you could see with the human eye, that you have the right to be in that space, you should be able to do that. And that's generally how the GSR is written, except for courts, for federal courts and courtrooms. And I think it's inherently wrong that all the case precedent will certainly say, certainly for a federal courtroom, not even talking about the hallways, but a courtroom, I can guarantee you there is not a federal courtroom anywhere in our country where you're allowed to go in and just record. You can't. And I think that's wrong. I think that violates the Constitution. I think we have every right and a duty as the public to know exactly what our government officials are doing, whether that's executive branch, legislative branch, or judicial branch. We have to have that watchful eye. We have to know what they're doing, and we have to hold them accountable. And especially in this day and age where our country is so vast, so geographically vast, and so vast in population. We have so many people, millions and millions of people here. There's no way that we, the people, can really affect, and our government is way too big. There's no way that we can affect change on a major scale on a regular basis unless the whole public is really informed and engaged and calling, demanding for some action, right?
And that's exactly why the government hates people with cameras.
Yes.
It sheds transparency. But the biggest question that I have for you is what happened afterwards. I went to the hospital. After the hospital, they shackled me up and released me to a sheriff's deputy. I asked the deputy in the van, "What are you booking me into jail on? What charge?"
Mm-hmm.
And he said, "There is no charge. It's just a hold for the U.S. Marshals." And I said, "Wait a second. Due process requires that before you take a free man and lock him in a cage, there has to be a charge. You cannot take me 45 minutes away off the grid to a jail on no charge. That's absolutely obnoxious." I said, "You need to get a supervisor because, the second that you take off down the road with me to that jail, your qualified immunity is on the line." He said he was just following orders. I gave him the story about Nuremberg, and just following orders doesn't cut it. And as we were nearing the jail, he asked me if I would just cooperate with the booking procedure, and I said, "Look, I have a lawful obligation and duty to resist tyranny and an unlawful confinement, and I'm not going to participate in my own kidnapping." And we got there. He got the booking deputy, and they literally, the handcuffs were cinched down so tight on my wrist, and they picked me up by the chain of the handcuffs. I was screaming. Like, that is the most pain. Like, it was horrible. I mean, I could feel my bones grinding. And they booked me into jail on no charge. The federal judge ordered my release the next day, and I was charged with the most lowest level federal crime of loitering, disorderly conduct, or whatever outside of a federal building. Something, I don't remember what the actual code was, but I guess the question is, am I correct in that they have to have a charge to book me or to book anyone into jail? What kind of leeway do they have with it? Does that count as kidnapping under 18 U.S. Code 1201? I looked up I went over the definition last night on a live stream.
Let's pause because I'm going to start losing some of the questions that you're it's a multi-part question. So I'm going to pause you right there so I can start addressing some of this. So as far as does a law enforcement agency have to have a charge against you before taking custody of you and, say, putting you in a holding cell? You would think so. But the way it practically plays out, and I, to some degree, I always hate to have to reference TV, but a lot of people know some of these shows. If you think about Law and Order, and you think about some of the shows that they're talking about, some other shows like that, if you think about those kind of cop shows they have, or Blue Bloods, or any of those things, they often will talk about picking up a suspect and holding them for up to 72 hours before they have to release you. And I'm going to be honest, it's been too long since I've been completely 100% into criminal law to remember where that 72 hours comes from. If I had to guess, it's from case precedent somewhere, but that was later codified in statutes or court rules or something of that nature, and it might vary by jurisdiction. But there is some sort of common sense element to allowing them to hold you for a short period of time without having charges filed against you. And let me tell you what that is. If they know that there's some sort of criminal activity that has transpired, but they need to do more investigation to figure out they know what class of conduct it was. But let's say the easiest might be murder. Okay, let's say they knew that you were the one responsible for the death of another human being, but they didn't have all the facts about the circumstances and they needed to investigate it more, they would probably hold off on charging you because they don't know if they need to charge you with first-degree murder or manslaughter or whatever. Like there's varying degrees based on your mens rea, your criminal intent, and other factors. Is it felony murder? Because did you commit murder in the context of committing another felony, like an armed robbery or something like that? So it makes sense for them to be able to say, well, we know you killed someone, so we're going to hold you, but we have a short window of time to do more investigation and more research to figure out what we need to charge you for. The other side of it too is, let's say there is, and I try to pick the easiest examples to go with, right? Let's say you have a domestic abuse victim who has called the police repeatedly asking for help, and she's gotten protection orders, and her ex is violating the orders left and right, and she's in danger, and they know he's armed, and they know he's violent, and he has a long rap sheet of violent offenses against people. If she calls 911, and let's say she lives in the middle of nowhere and they are on the other side of the county, by the time the sheriff's deputies get there, he has already broken into the home, and there's a struggle has ensued, and she ends up shooting him. By the time they get there, she's alive, he's dead. They may decide to withhold, they may pick her up, but they may decide to withhold charging completely. If they feel that it was a justified shooting where there's no criminal culpability there at all, and they shouldn't even file charges, they may still pick her up because, okay, they know that, she said, yep, nobody else was here. Or she might have even said, yep, I did it. Or she was on the phone with 911 at the time or whatever. They may very well pick her up and put her in holding without charges while they try to figure out what level that we talked about would be appropriate, or perhaps whether they should even charge her at all. So again, I just try to use the most clear examples, but does that kind of clear up
why? But it's got to serve an interest.
What's that?
I said, but it's got to serve an interest at the end of the day, not simply, there's got to be a true, like, I understand on a restraining order, if there's actually a violent threat, but simply what it certainly shows is retaliatory means towards a journalist.
So let me
yeah.
pause just for a second, because there's an analogy that just popped in my head. So essentially what you're saying is the tool, we need to have strong restrictions on that tool, putting somebody in a hold with probable cause, but without actually filing any charges. But we need to put strong restrictions on that tool because that tool can be misused.
Absolutely.
Okay, but pause for a second. Yeah. I need you to pause, because the same argument is the exact same argument that liberals make for why there needs to be gun control. Because guns can be misused. Therefore, that tool in the wrong hands means that we need to squash all the rights of everybody everywhere and make all these rules and regulations that make it hard to purchase firearms, or you have to report on firearms or whatever. But you see, the general principle is that it's not the tool itself that is broken. It is, your concern is about the misuse of the tool.
Well, yeah, and I think it's kind of apples to oranges, because you're talking about a person's liberty, so it's I guess the Second Amendment is a right, but liberty is the most cherished. I think we can all agree that a person's liberty is the most cherished of rights, the most sacred.
I would say life right? is the most sacred.
Well, life, yeah, life, liberty, and the pursuit of happiness. But I think it's there's a bit of a distinction there that before you take something, you can take somebody's liberty from them. It's got to be, there's got to be certainly a higher bar met than just who's a journalist, standing outside of a federal courthouse.
Now, see, here's that's where we get into some specific territory that is, I'm not saying I agree with it, but I can tell you that, for example, there are, I don't remember what format it's in. So I don't know if it was passed as a law, so it's actually a statute, or if it's federal regulation that stems from, the GSA in the CFRs, or if it's actually a court order from the U.S. Supreme Court. But I can tell you that there have been arrests made for people, regardless of what the issue is or the political party or whatever, that you're not supposed to be, say, standing on the steps of the U.S. Supreme Court, or even the sidewalk that's immediately adjacent to that property. You're not supposed to be right there protesting anything at all. Now, I disagree with that. I think that's unconstitutional. However, that is, I'll just call it a law at this point, because I don't remember, like I said, if it's statute, court rule, court order, but for the sake of argument here, I'm just going to call it a law. There is a law out there that says that. So practically speaking, if you are even just quietly, peacefully holding up a sign that says, screw the U.S. Marshals Service, and you're within that bubble of prohibited, area, just a peaceful protest that you could do across the street would be considered a violation of the law. So again,
how would that not clash with Cohen versus California? Seems to me that would go right against, because he wore a jacket into the courthouse saying "fuck the draft." So
okay, so hold on a second.
To it, I'm
going to pause for a second. First of all, I don't have all the cases that are out there memorized. Second of all, what we need to be extremely careful of, and I know that you're new to my channel, but case law, as they call it, case precedent, is not actual law. And although I use their own words against them, in fact, the petition for a writ of certiorari that I'm preparing right now for the United States Supreme Court, you better damn well believe I have a lot of United States Supreme Court cases I am citing to support my position. However, while I use their own tools to play their game to get justice and pursue the ends of justice, that our Constitution promises to us, nonetheless, court cases are not law. The whole point of court cases is to resolve disputes between parties. So to the extent that we want to, in our own discourse and our own conversations, want to talk about particular court cases, I think that reliance is misplaced, because we need to boil it down to what does the Constitution say in any given, scenario, and what do constitutionally enacted statutes say. Those are the only sources of actual law in our country. So, okay. Just food for thought.
It doesn't encroach on 14th Amendment grounds if the court rules one way for one person and then chooses to go against that precedent as far as that case. They decide one case one way for one person and then go against that and decide a different way for somebody else. Does that not get into 14th Amendment grounds of
equal protection?
Basically, equal protection because of the applicability.
So, first of all, that's one argument for why following case precedent, why there is value to case precedent, right? So I wouldn't say there's absolutely no value to case precedent, but unfortunately, how it has grown at this point is that there's this entire body of what's literally termed as case law by people all across the country, attorneys, judges, and just citizens will call it case law. And there is no case law because due process concerns would override and be more pressing in that moment than the equal protection. What I mean by that is if you have all this case law, right, where you have court cases that are from all different, in fact, let me just I just talked about this when I was interviewed in a podcast recently. So the United States Supreme Court alone, there are 11 official reporters. So where do you find the law? That's the point we're getting to. Where do you find the law? The United States Supreme Court, even if we want to say, when it comes to matters of constitutional importance, the United States Supreme Court has, the ultimate authority to make the final determination on those cases, right? Those controversies. And even that one court, there are 11 official reporters that you would have to look to. There are also 13 other different federal court types, not even like just various branches or locations. I'm talking about types. You have the Court of Appeals, you have federal circuit, you have circuit courts, you have U.S. Court of Appeals for the Federal Circuit. You have the U.S. Court of Federal Claims, U.S. Court of International Trade, district courts, bankruptcy courts, judicial panel on multi-district litigation, tax court for federal claims and armed forces, military service court of criminal appeals, et cetera, et cetera. All those decisions, nowhere are they all compiled together as one source of the law and where the law is. And then state courts themselves will have their state Supreme Court. Usually, their appellate court is usually called a Court of Appeals. And then they have district courts and circuit courts and, all that kind of stuff. So there is no place where you have one compilation of all decisions of, that you can just go look up for free. I mean, I'm not talking about having to use Westlaw or some other, expensive thing, but you can't just go and look up the law on, the theft of your car. If your car was stolen and you want to know what kind of repercussions the person's going to face and what, you can't go look up what the law relating to that is when we're talking about case law, because there is not one solid compilation of all that. And so to the extent that case law has been used literally as its own body of law against us to regulate and punish us, we the people, it is entirely unconstitutional because, it violates every notion of due process. If you can't even know what the law is before or after taking any kind of action, you have no notice. And one of the most basic principles of due process is notice and opportunity to be heard. If you are not put on notice what rules are going to be applied against you, then you cannot possibly have the notice and opportunity to be heard that is required for due process. So it's an important piece of so many freedom fighters. I'll just put it that way, whether it's First Amendment auditors, whether it's what do they call themselves? The sovereign nationals and all the rest of, different factions of freedom fighters. I'll just put it that way. So many rely so heavily on case law, case precedent, or what's worse is when they call it the common law, the way that the common law is like the savior of the people. It's the way back to freedom. Absolutely not, because common law literally is synonymous with case law. So anyway, although cases are an important tool to use against the other side, and especially when the other side is the government. And again, my website, you should check it out sometime, restorefreedomkh.com. There's tab resources, and then there's my current case that I have several court cases on there with tons of documents. But specifically, the one that I am bringing up to the U.S. Supreme Court right now is where the city of Ormond Beach, where I live, has brought 3 cases against me and my home. And they're literally trying to find me into poverty. They're literally trying to put liens on my home, levies on my personal property, my vehicles, all my stuff, and literally take everything I own and fine me every single day for all eternity. That's literally what they're trying to do. So I will use every single possible tool at my discretion to be able to fight back against that. But
Absolutely.
I also want to caution people when in my role as an educator in trying to tell people, where do we need to be? What is the right way to do this? We need to get our country back to the point where everyone just outright acknowledges that case law has no purpose in a constitutional republic where we strongly value having written laws that put the people on notice and give the people the opportunity to know how the government's trying to regulate them and how to fight back and change those laws. Because the people, when it comes to especially the Supreme Court, a lot of state Supreme Courts, but certainly the United States Supreme Court, that is a body of unelected people. How far removed from we the people is that unelected body? It is extremely far away in a constitutional republic where we the people retain ultimate control and authority and we elect people to do the day-to-day functions of government. We should not have those 9 justices making decisions that literally impact every single aspect of our lives with no repercussions whatsoever. There's no accountability. We can't just repeal what they have done.
Right. Well, one thing I've seen, especially over the last few years, is I truly 100% believe that we struggle to have a separation of powers. I believe there's a commingling of the branches. The reason that we have the separation of powers is to basically have make sure that one doesn't go off and well, it's to balance the system. But when you have 2 of the 3 branches, or even sometimes even 3 of the 3 branches working together.
Yes.
But I've seen a lot of times 2 of the 3 branches working together. I mean, that right there in itself outweighs the balance of powers. I mean, what's your thought on the balance of power? On the separation of powers?
Exactly. I think it's extremely important. And for how many things that the state of Michigan gets wrong, what I do want to do is give kudos to the state of Michigan, or at least the people of the state of Michigan that enacted the state constitution of 1963, which is still in effect today with just amendments that have been made. And there is literally in the words of the Constitution in the state of Michigan, it actually says that there is to be a separation of powers. So we have an implicit separation of powers in the United States Constitution when you have Article 1 talking about the legislative powers, Article 2 talking about the executive powers, and Article 3 talking about the judicial powers, and how those are delineated in different articles to different branches of government, and with those powers being separate for a reason. That is an implicit separation of powers. But I love that Michigan took it a step further and said, oh no, just for the dummies, we're going to go ahead and put it right in words that there is a separation of powers. And I think it is extremely important. Since you're new to the channel, there's a lot of things about me that I've repeated many, many times throughout the years, but I'm going to tell you a few of those things right here in order to answer your question. Number 1, I'm going to talk about the intersection of the judicial branch and the executive branch when it comes to administrative agencies, administrative judges, administrative law. Okay. But before I even get into that, let me just say that administrative anything is unconstitutional. Because again, when you have administrative laws that then empower an administrative agency to turn around and promulgate rules for the people that are used to regulate the people, that then makes it so that the people don't have direct control or authority over those who are drafting those rules or regulations, right? You have to be able to, the people that are voting yes or no on these on these regulations, they need to be held accountable in an election, and the people have to be able to have their voices heard. And when it's an administrative agency that is promulgating these rules and then used to turn around and regulate the people with those rules, it violates all notions of a constitutional republic, certainly of due process. So anyway, those agencies are totally not constitutional. But when you have an administrative agency, so for example, the case that I'm bringing to the United States Supreme Court, if you want to watch, there's a very brief video that's right on that page of my website I was talking about that has this case, all the case documentation I've put on there so people can use. That's actually what I started to tell you when I started talking about my website a minute ago. And that's restorefreedomkh.com/OB case, Ormond Beach case, OB case. Anyway, when you go on there, I show a little video at the very beginning that kind of goes over what the case is about, but then I have all the documents that kind of explain every single stage, right? It actually began in the magistrate tribunal. And so this is the way the state statute is written is that it's basically, the whole case is about, the city is saying that I violated their land development code, their LDC. And they are saying that the Community Planning Act, which is a state statute, requires them to put in place these land development codes. And the Community Planning Act, the state statute, gives them the way that they're supposed to do this and how they're supposed to hold hearings and the kind of penalties that they can put in place and, that kind of thing, and the procedures. And the state statute itself, I agree with Ormond Beach in what it says, which is that it allows either this body, I forget which board, or I think it's called an enforcement board is what they typically default to, that this enforcement board can essentially act as a court, a tribunal, and hold hearings about whether somebody has violated the land development code in a certain community. In this case, they don't have an enforcement board, they have a special magistrate. And so the statute allows them to replace an enforcement board with a special magistrate. And he, at least in this case, he was a retired circuit court judge. So he has the experience of coming, at it from that angle, and is not just some Joe Blow off the street that wouldn't necessarily understand the Constitution or the laws. But at any rate, he is an employee. He is paid by the city of Ormond Beach. And that's typical in a lot of these administrative law type scenarios where you have the ALJ, the administrative law judge, the special magistrate, whatever you want to call them. They are typically paid by and employed by the same agency that is bringing the cause of action against you. How is that a neutral third party? How does that by itself not violate notions of due process? But you have this agency, which is literally part of the executive branch, right? They're tasked with enforcing the law, although they should be making sure it's constitutional in nature before they enforce it, which they don't. But regardless, they are tasked with enforcing the law, and yet they're in a judicial role. They're deciding, they are literally serving as the trial court. In fact, in Florida statutes, for example, with this particular case, in order to appeal, or in order to say, I don't like what the magistrate has done, you literally have to file a direct appeal to the circuit court under statute 162.11. And it literally is an appeal.
And there's a conflict of interest. Yeah.
Well, and it's an appeal. So literally what it means to have a true direct appeal means you cannot introduce new evidence at this next level, at the circuit court. You have to only go with what evidence was introduced at that special magistrate hearing or, administrative law hearing or whatever. And most people don't think to have attorneys. Like if you're going to an administrative law judge, to get your driver's license back, or an administrative law judge about, a code violation, a municipal code violation, or a variety of areas where these administrative law judges or special magistrates are used, a lot of people are thinking, well, the process is informal, which is true. It's often informal. How, people are thinking, well, I can't afford an attorney, number one, but why would I need an attorney? It sounds like, I just show up to this meeting and I tell them what I want and whatever, or I give them my defenses or whatever. And the problem is people are not then knowing that they have to preserve the issues. You have to raise every single issue, legal and constitutional, that you want to raise. You have to raise it at that hearing. You have to present any evidence you think you might want to get in. If you find yourself, fast forward, think of it, if I ever want to appeal this all the way up to the state Supreme Court or the United States Supreme Court someday, I'm going to need to have all that evidence somehow introduced right here and right now. And people don't think that way, especially in these informal hearings. And why would you if it's an administrative side of things, right? It's the executive branch you're dealing with, but all of a sudden it like snuck over into the judicial branch, and you are held to only that evidence and only those legal arguments which you raised properly in front of that particular tribunal, which is of the executive branch. So that's just an area where the two are being commingled, and they're being commingled on a regular basis. Millions of people nationwide are being affected by these administrative agencies, these administrative hearings happening, and their rights are being just railroaded because it's not made clear this is actually in place of an actual court, and you don't get a redo in front of an actual judge later on.
Yeah, it's very dangerous. It's not just, and it's widespread. It's definitely, that's what the separation of powers is meant against. That very thing that it was built to protect against is
right. And when you have, like in this situation, when you have this special magistrate, and he's employed by, gets the paycheck from the city of Ormond Beach, when they, when he decided, okay, well, they won their case, he's already coming with the viewpoint of they win unless I find something compelling about her argument that says they shouldn't win. But otherwise, he's coming with the frame of, that frame of reference or that viewpoint that there's a presumption that the city is won. They already get whatever they've asked for. And if he doesn't come with that frame of reference, then they're just going to pick somebody else to serve in that role and pay somebody else to do that job. And they have every right to do that when it's their own employee, right? So it's a total conflict of interest. And they are the ones that are, sometimes in courts, you will have a judge say to the prevailing party on an actual court, you'll have a judge say to the prevailing party, could you, defendant, could your counsel prepare the order? They'll say what the order is verbally on the record, and then they'll say, counsel, could you please prepare the order as I've just said it and submit it to the court. And then in Michigan, there's a specific procedure of a 7-day notice of presentment, where if you are tasked with preparing an order for the court, then you have to send it to the other side, and they have 7 days to make any objections to the order. If they're saying, no, that's not what was in the court. I think I'm hearing an echo of myself in the background. There's something going on in the background. But anyway, so there is a time and place for that, but with certain procedures being made. Now, in this scenario, he didn't look to the other side and say, we're going to follow this particular court rule that everybody has access to and can know that it's there. Can you go ahead and prepare this order and send it to the other side, with like under a similar 7-day notice of presentment, and then submit it, and then we'll get it signed that way. No, every single case, the city attorney's office prepares the orders for him, sends them over, and he just signs them. He doesn't ever create his own orders. And I can tell that because I'm observant, and I look at the bottom of all the orders, and they're prepared by the city attorneys. Like they have the directory, the file path, and the file path was from the actual attorney, Anne Marie Emery, or whatever her stupid name is. It was from her computer, her files, where this was made and where they're all made from. And it's just a format, it's a way of doing things. And of course, she didn't send it to me to review and approve or be able to make objections to, so I had no notice and opportunity to be heard. But it's just another commingling. But it makes sense when they're both on the same side, when they're both part of the executive branch, then why would they do it any differently? They're going to commingle everything. So it's just a real life example that I have about how important it is that we do truly have a separation of all three branches of government. We don't have any commingling of branches of government. And in fact, there have been cases that I cited, which are on my website. There's a lot of stuff I did in 2020 to fight the governor of Michigan when she was issuing executive orders. and some briefs that I submitted to the Michigan Supreme Court back then that I don't even think I have all on the website yet. But anyway, they would be available at the Michigan Supreme Court's, their docketing system. You could see them that way. But anyway, in those briefs, I argued over and over again the importance of the separation of the three branches of government. And they're of course, I'm going to use their own case law, their own case precedent against them, right? And so I did find cases that specifically talked about if you have a branch that is trying to exercise the powers that properly belong to another branch of government, that action is invalid. And so that, I would say that premise still holds true all over, and it should be the same premise in every state. So anyway, that hopefully answers your question.
So we know it's wrong. So what do we do about it? I mean, whenever it happens, what can be done about it? I mean, I guess obviously you have to rally the other of the three branches that, if there's no commingling there, but what do we do about it when there's this commingling?
So, sorry, I have no idea what, something popped up on my screen while you were talking, and I don't know enough about YouTube to know what was happening. So it
I believe
distracted my attention.
That was a super chat by Blue Line Transparency. He just sent a $5 super chat.
And I appreciate that. I still don't know much about how it functions or what I was supposed to do on my end. So it was distracting to me in the moment, so I apologize. But to answer your question about what do we do about it when these things happen, there is no Staples easy button. So there's no quick answer to that. I would say the first and foremost thing we need to do is do what I've been trying to do for at least the last 5 years, which is educate people, educate those in government, educate the people. So educating both sides on what the Constitution actually says and what the proper role of government is. And we need to have the DOGE on steroids. Like, it has not even remotely done what it needs to do. It has done 1/100th of what it needs to do. We need to reduce the size of our government and the regulations and statutes being used against the people to regulate the people by 95%. And
Amen.
What we need to do is, it's not going to be done overnight. It's going to be generations of work to do this. So we need to make sure we are constantly educating people so that every time they go into anything, any government interaction whatsoever, they are not thinking as we do, as we are essentially taught and brought up to believe. We're taught that, if the government is saying something, it must be true. It must be, it is fact, or it is the law, or if they're telling me I got to do something, I got to follow the directions of the government, unless there's some specific reason why not to, right? And a lot of Americans don't even have that unless. They just go, well, the government says I got to do something, I got to do it. They have the right to tell me what to do. So we need to make sure we're educating people on the fact that our rights come from God, not the government. And the government's authority doesn't come from God. The government's authority in our country with the Constitutional Republic comes from we the people. That we the people retain ultimate control and authority, and we are lending out authority for specific roles and functions. So we are not lending to the executive branch any kind of authority to exercise judicial powers whatsoever. None at all. Even if our elected representatives in the legislative branch have tried to allow that blending of the executive and the judicial branches. So we need to educate people. We need to have that frame of reference that our rights come from God and not the government, and the government cannot act unless it has been specifically given permission to do so. And even if there is a local, state, or federal law that pretends to or proclaims to give the government power to do something, if that law in and of itself is not constitutional, it's void on its face, and it should not be followed under any circumstances. We need to teach people those basic concepts so that in every single interaction with the government, whether it comes to, getting their assessment of their property taxes, or going to the DMV and dealing with an issue with a driver's license or whatever it is. We need to make sure that that is the frame of reference that every single citizen has when they walk into those scenarios and they're interacting with government.
I've advocated for a while that our country needs two things in particular. We need more civil disobedience, and we need more people that are willing to file lawsuits. Because that's really ultimately these government employees, agents, officials, they're not having to pay the cost of the lawsuit. But you know what? When the people find out how much of the people's money these idiots are wasting, when people expose that, for them doing the things that they do, maybe the people as a whole will get fired up, mad enough to actually, come together, because that's what it's going to take, is a collective effort.
And that's one of the benefits of 2020. When our governments were by and large in red and blue states alike, when they were shutting down our society, when they were telling us we couldn't have our businesses open, especially, I was in Michigan in 2020 and 2021, when the governor was issuing executive orders like they were going out of style, when she was telling us, we couldn't go into government buildings, we couldn't renew our driver's licenses, but you had to, but you couldn't. When she was saying, you couldn't go see your loved ones when they were in the hospital, when you couldn't even get procedures that you needed by medical providers because, they weren't deemed necessary. When you couldn't go to AA or NA and have your meetings, when you couldn't get, your anger management or your counseling or your therapy, when children couldn't get their ABA or other therapies and resources, when kids were being kept out of schools, everything, when businesses were told to shut down, but mom and pop shops couldn't be open, but the strip clubs and the liquor stores were always allowed to stay open through COVID. I mean, all of that stuff, it's speaking out and telling people, no, it's standing up and saying this isn't right. And that was one of the benefits in 2020, was that it was so egregious. It was such a slap in the face that even people, regardless of prior political voting, regardless of whether they had never been active in politics at all in any way, shape, or form, they stood up and they said, enough is enough. I don't want to do this anymore. This is not okay. We cannot continue infringing on rights. I mean, it is so inherently wrong. And that was a benefit. That was honestly, I think it was a good thing that all that was happening in 2020, because it was a slap in the face for so many people that it woke them up. Now, unfortunately, a lot of people have since then gotten more complacent, and they're like, oh, well, especially now, Trump's back in office, or, maybe in my state, I have a new governor, and maybe now I have, I'm back to having a Republican-controlled legislature, or whatever the case may be. Well, I was able to find a job that didn't require me to get jabs and masks and mandates and all this stuff. Whatever the case is, people have gotten too comfortable and reverted back to the pre-COVID era, where they are going, you know what? It's somebody else's job to fight for my freedom. It's somebody else's job to wake up and pay attention.
I think personally that COVID served a bigger purpose to the government, because I think that 2020 and COVID was all a big test for government compliance of the people, to see where the people as a whole were at on submitting to the government. And you know what's funny about that?
You know what's funny about that? It's funny that you say that, because 100% I agree with you, and probably everybody in the chat would agree with you that 2020 was used as a test to test our compliance. But I can tell you even more than that. Do you remember about what happened in the early stages of COVID in Michigan in 2020, April 30th, 2020 to be exact? When our state was shut down, we held the first in-person rally at the steps of the Michigan Capitol, April 30th of 2020. And Dr. Not Fauci, but the other one, Birx, I think was her name, and the one that had the ugly scarves. And she was doing I don't remember. But at the time, she was the one doing the COVID updates for the nation. And at the time, Governor Whitmer was doing daily updates for the state of Michigan on COVID and all the numbers and all the scary stuff. Well, anyway, they went in and said, oh, my face made national news. Of course, not my voice. They couldn't actually hear people, they didn't want people hearing about what I was saying about the Constitution. But my face made national news, and that doctor with the scarf made it a point to say that basically I was, the example of the super spreader event. How dare we have people within 6 feet of each other and protesting on the steps of the Capitol and risking the safety and lives of others. Anyway, I went, so in this, once I was done with my speech, there were other people speaking at that event, and I went into the Capitol, because the legislature was in session. But the Speaker of the House, who was actually Republican, he at the time decided that he was going to keep the doors of the legislature closed. So you could go in, but you couldn't actually go into the room where they do the voting. You had to be outside. And there was this huge line of Capitol Police, the red coats, because they have red coats that they wear. And then between them and us were the line of Michigan State Police. And then on our side of things, you had a lot of militia members and other people that were armed and angry, and they're in the faces of these state police and Capitol Police saying, you have to let us in. And of course, they never did open the doors, and they never did let us in. But instead of being, and I'm actually in some pictures that made national news, where there's one guy's picture that made it all over national news, where he's screaming violently in the face of these cops. And they're talking about how horribly violent we were, right? They were utilizing April 30th, 2020 as the test drive for what they were trying to do and trying to get the people to do on January 6th, 2021. But at any rate, we were not violent. They tried to portray that we were violent. And anyway, I went in there, and as soon as I saw the screaming and the tensions, and you had our guys with guns and their guys with guns, and I'm like, this could be really bad. So what did I do? I decided to walk right up to the middle of it all, and I stand literally directly in between the guys screaming at them to let us in and the guys who are not letting us in. And I talked to both sides, and I tried to, play mediator. And I knew we had every right to be in there, but I knew violence and aggression was not going to be the way to get us in there in that moment. So anyway, when they wouldn't let us in, I ended up looking at the screens to see what bills they were voting on. And I was educating, the whole crowd got quiet, hundreds of people, we were near a stairway. And so you had people out in the rotunda, you had people filling the whole hallway, you had people in the stairways, and hundreds of people were standing there listening as I was explaining what they were voting on, what the bills actually contained, what they were doing. And people were hungry to know and hold their government officials accountable. And so that was the day that they actually had FBI informants that were in there as agitators trying to incite some sort of violence to see what they could get us conservatives to do. But I stopped it. I went in there and I made peace of the situation. I tried to bring information to the people who wanted it. I essentially tried to bring out the information of what was happening in that behind those closed doors out to the people who needed it, in a way that was trying to find a solution when they were doing us wrong, when they were not opening those doors. And so that was the day I later found out, and I don't know if you heard about the Null brothers. But they were ones that were later arrested with the supposed kidnapping plot to kidnap Governor Whitmer, made national news.
Yeah.
So anyway, the Null brothers were two Michigan militia members that had served as security for me at dozens, if not hundreds of events all across Michigan in 2020. And so I had gotten to know them. And anyway, when they were arrested, they were told by the state attorney general that they could get off of their charges if they would just give some dirt on me. And not only that, through the course of their case, which took, I think, 2 years, 2.5 years maybe, to get dismissed. I can't remember if it was 2 or 3 years, but anyway, their charges were eventually dismissed. But in the course of the investigation of what they found out was that even back to April 30th, 2020, we had FBI assets in the in that state capitol, and that they were trying to, get something started as the precursor to January 6th, 2021. And because I didn't let that happen, from that point on, I was on the FBI watch list starting April 30th, 2020.
The FBI is the most disgustingly corrupt political weapon. That whole organization needs to be disbanded and then rebuilt. It's beyond the state of repair.
Well, the FBI, here's another crazy. Here's a crazy notion. I would say anything with an acronym probably needs to be gone. But in all sincerity, we should have, our armed forces that are used to defend our country against outside forces, right? And then one agency that is used for law enforcement purposes within our country for federal offenses. One, and that's it. We shouldn't have CIA, FBI, DOJ, all the initials and acronyms and everything that exists.
The alphabet agencies, yeah.
The whole alphabet soup should not be thrown at the American people with those unlimited resources from our tax dollars to be, to squash our constitutionally protected God-given freedoms. So if it were up to me, if someday I get elected as president, because when I was younger, I used to say my goal was that I would serve as an attorney, and eventually I would be president of the United States. And then after that, I would serve as United States Supreme Court Justice, where I would remain on the bench, until I died. And doing it in that order and in that way, I would be able to clean house. And I had goals, from the time I was, in my teens, to do what Trump is starting to do and clean house and eliminate most of the laws. And he hasn't done much with that, but that was my goal, to specifically eliminate most of the laws we have on the books, to eliminate every single federal agency's supposed authority to regulate the people. Because no government agency should ever be able to regulate the people. The only purpose of a government agency, really, if the fact that there has to be a government agency tells me that particular function of government or branch of government is too big. It's too big for its own britches if you just can't have the actual elected officials doing their jobs.
They need to get rid of victimless crimes, and they need to also reduce qualified immunity. The fact that these officers can violate somebody's rights and know that they're doing it and then fall back on qualified immunity. That's the one thing Justice Clarence Thomas is basically, he's kind of wanting to push to, it sounds like, to strengthen qualified immunity, and that is a bad road to go down.
Immunity needs to go completely. I mean, the whole concept, again, things you don't know about me. In 2020, I authored a constitutional amendment petition that would have modified the Michigan Constitution. And as part of that, I was clearly giving standing to individuals. If a government official had violated the Constitution, they had standing automatically to bring a cause of action against that government official. And if a government official was found to have violated the Constitution, I had it set up in common sense ways so they still had due process, right? Because even people in, government roles should have due process, because maybe they're just wrongly accused of doing something, for example. But at any rate, that there were significant consequences. And I think it was like the second time you're found guilty of stepping outside of your oath of office, you are forever barred from ever holding any public office, and jail time and the rest. So anyway, it served a purpose to essentially totally wipe out the whole concept of immunity, governmental immunity, qualified immunity, all of that nonsense, because it doesn't have a place in a constitutional republic at all. But no. Something else you mentioned, it gave me I wanted to say something about it, and you ended up saying a couple things. But anyway, go ahead.
It was Well, it was Justice Thomas about strengthening qualified immunity, and it was damn it, what was I saying? I just had a case of the stupids. Just kind of come over me. So
well, I'm blonde, so who am I to judge?
When you said you blanked out, it made my brain think, well, damn, mine just blanked out too.
Well, anyway, yeah, there was something in particular that I wanted to touch on, but regardless, there's a lot of work we need to do. So one of the other things that is important besides educating people, back to the question you asked a long time ago, it's important that we educate people, but it's also important that we start doing the essential job of getting the right people into office. So if you don't ever want to run for any office whatsoever, if you don't like the government and you don't want to be in government, you are who is called. You are the exact person who has the duty to serve in government. We need to get everybody serving in government that doesn't want to. We need to get everyone who understands basic concepts of constitutional protections for our God-given freedoms. We need those people serving, whether it be on the school board, whether it be on your city or county commissions or councils, whether it's on a small thing like a zoning board of appeals or a planning commission for a local community, whether it's state rep, whether it's in Congress, governor, mayor, sheriff, prosecuting attorney, public defender, doesn't matter. Any kind of governmental role, dog catcher for communities that still have that, any kind of governmental role, any elected position whatsoever, we need to get average, everyday people running in those positions, and we need to support them. So we need to recruit them. We need to support them. Like I've said over and over again, when I moved down here, people were like, well, you're going to run for this, you're going to run for that, right? And I'm like, you know what? I'll go wherever God calls me, but I don't ever want to have to be in charge of a campaign again. I've done that a couple of times, and I don't want the administrative responsibilities. So I will be the candidate. I will bring, the guns blazing with the Constitution and the law on my side, but I am not going to be the one that has to deal with all the campaign finance reporting and all the other nonsense that, restricts us.
It's a nasty job. I would fire everybody the first day. Because it's the problem is there's really no, it kind of gets back to, the fact of, is there really such thing as good cops out there? Because once a cop, and they're always going to take the back of their blue line brothers, once they witness another cop violating somebody's rights or, assaulting somebody, doing something that they know is wrong, but they choose to stay silent, turn a blind eye to it, because they are protecting their brother, or they're worried about losing their job security or being retaliated upon. But the second that they stay silent and they basically ignore, which I'm sure all of us have seen, it's so common.
Yes.
But the second they do that, they cannot be considered a good officer. They cannot be considered, honestly, in my eyes, they can't be considered a good person. Like when you see something and allow it to happen, when you turn a blind eye and allow that to happen, you put yourself in the same boat as the person doing the wrong.
Yes. What's the saying that the only way for
no?
Well, the only way for
it wouldn't be that. Yeah.
The only way or the best way for evil to triumph is when good men do nothing, or something to that nature. I'm chopping it up, but anyway, exactly. And I'm going to throw this out there. This isn't exactly where you were going with this, but when you talk about cops in the slang term that we have for that, I have now come to the conclusion, after years of doing these constitutional discussions and battles and court cases and everything, I have come to the conclusion that there should be no law enforcement agencies where the head of that agency is not elected directly by the people. So, for example, every county across the country has a sheriff, and that sheriff is elected by the people, and then his deputies, are not elected. They're, they work for him. But if the people don't like what they see, if they have concerns about the manner in which he is trying to execute the law, then there's a way that we, the people, can stand up and do something at the very least when it comes to election day. And police agencies are never elected. They're, what's a commonplace scenario is where the chief of police answers to a city manager, or sometimes a mayor, sometimes a city council. But regardless, the chief of police never answers to we the people. So there should not be ever any law enforcement agencies anywhere in our country at any level, local, state, or national, where the head of the agency is not directly elected by the people.
You want to hear something scary about this? Is a dangerous. And I'd love to hear your feedback on this. Back where I came from in Mississippi, Lafayette County, Mississippi, the sheriff, the long-standing sheriff over there, his name was Buddy East. He's the longest-serving sheriff in Mississippi history. Served as sheriff for 46 years. Was reelected 12 terms back to back, and guess what? His son, Joey East, was the chief of police in Oxford, which is in that county. And it was long believed that when Buddy died, or he wasn't going to step down, he was going to hold office until he died. As soon as he died, his son ran for sheriff, and it was a transfer of power. So it's a family dynasty that has held the position of sheriff in Lafayette County, Mississippi, going on. It's been over 50 years straight now. I'm a strong advocate for term limits. I think every state and federal official, you've got to have term limits. If something like that is actually allowed, where somebody can run 12 terms back to back, that just harbors corruption. Because you got to have new people to come in and shake it up, and people have to know that new people are going to come in and shake it up after this amount of time.
Exactly.
Or
it becomes a monarchy within supposedly the constitutional republic that we have.
Yep.
Or an oligarchy,
yep.
I guess, the control of a few. But yeah, it shouldn't be the good old boy network that runs our country. It should be, a constant cycle of people. And absolutely, just think about Congress. That alone, if you wouldn't have the entrenchment of the lobbyists there if you had people that could only serve 2 terms and then they're out. Because you'd have this constant influx of people, and they wouldn't have long enough to sink their claws into these people and begin to own them and make them rich and powerful and wealthy and all the rest, So
that's right.
Anyway, I realized that I had not been checking at all to see if there were any other questions.
I know, and I'm sorry for holding up the line. If anybody had any questions, I figured you would just say, "Hey, I got another question." But it's been some great dialogue, that's for sure.
Oh, absolutely. And it looks like, okay, I do see one question. I almost missed it because it didn't have the all caps, but I do have one question. So if it's all right, I think what I'm going to do is go ahead and get to that person's question, and then probably round it out for the day, because I have to get back to drafting this petition for the Supreme Court. And
I have to go do an audit at a police department. So I've been outside of it for this call. So I'll whenever you finish up, I'm going to go and audit this police department, and then I'm going to keep on moving.
Well, I would love to have you call in again sometime. I'm sure we could have more lively discussions on a bunch more topics.
What is your email address?
The main email for Restore Freedom is contact@restorefreedomkh.com, and Lori will probably be, she's on the ball, and she'll probably be putting it in the chat. But if you go to my website, you should be able to get, there should be a way to get that email. So
awesome. Hey, I appreciate it. It's great talking to you, Katherine.
Yes, thank you. Have a great day.
You too. Bye-bye.